Other questions? Mm-hmm.
If at some stage in your life you have to go to the nursing home, what are assets that you could protect from them taking it to use for the premiums?
Well, virtually everything now. Your home, your homestead property is exempt, so that you can put any amount of value into your home and still qualify for Medicaid in a nursing home. An automobile is exempt. Most of your household furnishings are exempt. Everything else will be counted as an asset. That includes, doesn't of course include life insurance, because that doesn't pay unless you pass away, unless it has a cash value. Annuities will count, monthly income will count, but there are ways that we can structure all of that.
They take the IRA away, too.
Well, no. What they can take is your monthly payments out of your IRA. They can require that you begin to take distributions from your IRA if you haven't, and that the distributions be reasonable, and then that goes into your monthly income. Now, I will say this about nursing home planning. The monthly income is going to go to the nursing home. Now, if you look or you talk to someone about a nursing home, about what are the qualifications for your monthly income, it's limited to, I think it's $2,092 a month. And if you get more than that, then you're not eligible. There's a very simple thing we can do, which is called a qualified income trust. And it's a silly, silly thing to do, where your monthly income goes into this trust and then gets paid to the nursing home. But your monthly income will get paid to the nursing home, but not the principal of your IRA. But for nursing homes everywhere, because it's a federal law and then the states implement it, when you do pass away, your assets will go to repay Medicaid for what they paid. But count on the fact that whatever Medicaid pays will be less than you would pay out of your pocket.
I understand there's a look back of 5 years that you could protect it. Is that anything still in effect?
Yes. Now, it used to be 3 years, but now the look back is 5 years. So, but what I'm talking about are transfers that we can make immediately. It doesn't have to have been made 5 years ago. Some transfers can be made. For example, you can make unlimited transfers to a spouse. However, there are higher limits for the community spouse. The community spouse can have a certain amount of assets. If they're higher than that, then we have to do some things to structure that as well. But you can transfer to a spouse, you can do a personal care contract, which means that you prepay someone to provide services for you. For example, you prepay someone to manage your accounts, to pay your bills, to take care of your house, to visit you, to go to your care plan meetings, etc., etc. You can prepay for additional care in the nursing home. If you want to bring Sandra to the nursing home, she'll probably tell you she's too busy, but you could prepay Sandra to come to the nursing home and do your physical therapy. And that's all legal, that you can do all of those things. So there's a number of things that we can do, certain kinds of annuities you can purchase. There's a number of things that you can do. And you cannot move millions of dollars. That won't be effective, but you can move hundreds of thousands and have that be effective. Yes?
Liability, let's say, go back to a bank account, let's say, and you have your son or daughter or wife or husband as a co-owner, and they get sued for something. What about liability?
Well, if they're a co-owner of the bank account, then it's partly their asset. And it can be attached by a creditor, including a judgment creditor. Now, the thing to understand, though, about litigation is just because somebody says you're liable doesn't mean they can come get your assets. Just because you are liable doesn't mean that they can come get your assets. Just because they sue you doesn't mean that they can come get your assets. The only time they can come get your assets, or if it's a child, their assets, is if they sue, they go to court, they win, they get a judgment. So that's a pretty good long process. and my point is you have plenty of time to rearrange things.
Well, what I'm thinking of is if they don't have access to the assets, probably they won't get, it's less likely they'll get sued. If they
Exactly.
don't have it. So that
Well-
would be a point.
That, true, very true. And if you put your account in a trust, and they happen to be the trustee, then it's not attachable. You can't go get assets that belong to somebody else and you just happen to be the trustee. They can't get it if they're a beneficiary either, because I don't think there's a lawyer breathing who doesn't do the spendthrift provisions of a trust or a will. And what that means is we provide there that for beneficiaries, the asset belongs to them when it's in their hands and not before. So that you cannot take a loan or pledge or have a creditor, including a spouse, attach your right to be a beneficiary under something. They can only attach it once you have it in hand and it's been distributed to you.
Thank you.
Mhm.
If I were the beneficiary, and I died, and I have contingent beneficiaries, can that all be taxable? Is that free and clear, or?
Depends upon who they are. Currently, there is a $5 million lifetime gift and estate tax exemption for everybody. So, now, having said that, that's due to expire the end of this year. And it could revert back to $1.5 million lifetime gift and estate tax exemption. So, I mean, you go ahead, get out your magic 8-ball or your crystal ball and predict what Congress is going to do about the taxes. But, you know, if you want to bet that they're going to take this back to $1.5 million, I will take the opposite side of that bet. Because I don't think anybody has a political will to do that. And they might change it a little bit, but once taxes are in place, it's very difficult to actually raise taxes. I think they're probably going to keep that or something close to that. So we're talking about a pretty high exemption right now. And Florida has no estate tax itself. Any other questions? Mm-hmm.
If your paperwork is 15 or 20 years old, but there's no changes you want to make, there's still valid?
Absolutely. If your paperwork is 15 or 20 years old and it's still working for you, your lawyer did a good job. Because that's my goal. My goal is that you only have to go through this process once, and then your paperwork works for you. That's why I call it life planning. So, good for you.
Are there cases where you see that with the documents that were drawn up several years ago really aren't pertinent to the way the situation is now, that needs to be reviewed?
Yes. Oftentimes, if you have any doubts about it, it's a good idea to have that reviewed. Absolutely. Mhm. I mean, for example, there are many times provisions where, you know, if all you did was provide a guardian for your minor children and now they're grown up, no big deal. But if you provided all kinds of trusts, for example, if you wrote that, you know, your children's assets will go to, you know, your spouse or an aunt or uncle, you might want to change that. You know, if there are things you no longer have and you provided specifically for them and you don't care, you can leave it in there, no big deal, it'll simply lapse. But if you have some additional assets that are not provided, that's something you want to update. So yes, there are many times when you might want to look at your documents, make sure that they still do what you want them to do. Any other questions? Mhm.
How often should you have your documents reviewed?
Well, you know, there's not really a stock answer to how often you should have them reviewed. You might want to think about them every year when you do your taxes. You know, it's a good idea to keep them, you know, with your tax returns, and as you put together your, you know, documents for taxes, think about it. Okay, well, I might just look through my trust and see, what does it say now? What doesn't it? I might look at, do I have a power of attorney? I didn't think I needed one before, but do I want to do one now? Etc. A power of attorney is something you probably want to have looked at. If you have a power of attorney that's many, many years old, personally, I would do a new one. Because when you take a really old power of attorney to a bank, the chances are they're going to challenge it. Even though it's effective, and it may be effective for everything you want to do, they're not familiar with it, it's obviously not the current form, you're not dealing with the vice president for legal affairs for the bank, you're dealing with whomever, the branch manager or the teller. A power of attorney is something, if it's really old, I would just update it so that it fits the current form. If you did it 2 or 3 years ago, I don't think you need to do that. But if it's 15 or 20 years old, I would at least think about it.
I guess that was my question, how old is too old?
Yeah. I mean, if it's in the last few years, I wouldn't worry about it.
Yes. 7 years, 8 years?
You might want to think about it. You want to be sure that it will cover everything. You want to be sure, look at your power of attorney and determine whether it uses the language that allows your agent to manage assets and apply for government benefits. It may or may not say Medicaid specifically, but you want it to be broad enough that it will allow your agent to make the planning necessary for government benefits. If it doesn't say that, you probably want it to.
But it just changed in November, so it's probably a
Well,
good idea to change it, get it updated, wouldn't you say? They changed it?
Yes and no. Florida lawyers knew this was coming because, you know, statutes aren't passed usually on the last day of the session. Sometimes they are, but usually not. This one was not. This one went through the bar and it went on and on and on. And everybody knew it was coming. So Florida lawyers have been preparing for this and putting this language in powers of attorney for at least 2 or 3 years. What really changed here in November of 2011 is that now you actually have to initial next to certain provisions. Now, I know I shouldn't say this, and I certainly shouldn't say it on camera, but I mean, how many of you read every word of that when they hand you a stack of papers that's 12 pages long and says initial on every line? How many read it? Good for you. I don't. I say, what does it mean?
Yeah.
And then I initial, right? And of course I explain what it means to people, but you know, they wanted you to be sure you understood that you were giving people, for example, the power to make a gift of your assets, the power to disclaim your right to receive from a trust or a will, your right, you know, your need to make Medicaid planning. They wanted to be sure that you understood you were doing that, so they said you have to initial next to each one. That's the big thing that changed in November of 2011. It's longer to sign them. But for several years, the lawyers knew it was coming, and so we always provided for it anyway. And you know, I would say certainly 2 or 3 years, you're safe. Getting around 5, I'd read them to make sure. Any other questions? Well, thank you very, very much. It certainly has been my pleasure.
Well, if that didn't give you enough information, I don't know what would. I thought it was excellent. Thank you again.
Thank you.